So in our previous Spark, we highlighted the transparency obligations imposed on interactive and generative AI systems. And we also said that this is among the fewer obligations the providers or deployers of such systems have to adhere to. But that is not all there is, of course. The regulation of such systems, designated as general purpose AI systems in the AI Act, is actually quite confusing, but hey, that's what happens when you rush things into law. So general purpose AI systems are AI systems which are based on a general purpose AI model and which have the capability to serve a variety of purposes, both for direct use as well as for integration in other AI systems. Extra points going to those that notice that they are based on general purpose AI models. Now, what is a model? We didn't have that before, did we? No, we did not. So general purpose AI models are, again, according to the law, AI models, including where trained with a large amount of data using self-supervision at scale, that display significant generality and are capable of competently performing a wide range of distinct tasks regardless of the way the models are placed on the market. And they can also be integrated into a variety of downstream systems or applications, and they do not include AI models that are used for research, development, or prototyping activities before being placed on the market, of course. Makes sense, right? Well, it starts once you reread this about a gazillion times. So the crucial difference here is that models are not ready for use. They are mere code. Even if trained, they do not even have a rudimentary user interface. Zero. Nada. Unless you have some basic programming experience, this means that you will not be able to have a fun little chatbot on your website anytime soon. Once they are brought into a usable, and I mean an average person usable form, they become a system. Why is this important? Well, because most of the AI Act's requirements are imposed on general purpose AI model providers, not system providers. So the code developer and the training data collector, rather than the company integrating that on their website. Phew, thank God, that's a relief. P.S. If you do integrate a model on your website, you are still the system provider, but more on that in a sec. Back to the model providers. So they will have to adhere to certain obligations regarding training data, copyright, documentation, etc. And if their model also falls into the category of models with systemic risk, which basically means trained using ridiculous amounts of compute or having the potential to cause severe issues in the EU market, there will be certain extra requirements regarding red teaming, cybersecurity, etc. The hurdle to be designated by the Commission as a systemically risky model, however, is likely to be quite high and reserved for the strongest players in the game, thereby also kind of complementing the recently adopted Digital Services and Digital Markets Act that also target those with the big guns. Therefore, I will also not waste much time on these. Those guys can pay for someone explaining that to them. What this means for general purpose AI system providers, aka an average company integrating a chatbot on their website, is due diligence in picking your model provider and the standard stuff, so monitoring, documenting, using as instructed, etc. And maybe trying to avoid the models with systemic risks, as these are highly unlikely to actually be able to fulfill the AI Act's ambitious requirements. Oh, and most importantly, do not use any general purpose model or system for a high risk purpose, because if I can tell you one thing with 100% certainty, it is that none of the existing models are capable of fulfilling the high risk system requirements, and I, for one, am highly skeptical that they will ever be able to do so. And, well, that's it. Simple enough, right?